Good day. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. Today I'm going to talk about a methodology for resolving some difficult questions under Chapter 13, where the courts are badly split. First off, let's take the question of Social Security benefits. As we all know, of course, Social Security benefits are excluded from the calculation of disposable income in Chapter 13, so that means as a general proposition that someone does not have to pay Social Security benefits to creditors under a Chapter 13 plan. However, some courts, not all of them, have turned right around and said that nonetheless the court may consider Social Security income under the so-called abuse test in Chapter 13, so that at the end of the day, that Chapter 13 debtor could end up paying some of those Social Security benefits to creditors. In my column on ABI's website today, I have dealt with a different yet similar issue, and that has to do with exempt assets. In a Chapter 13 case, of course, assets can be exempt. In the case that I wrote about today, it dealt with a personal injury claim, which was exempt under state law. Nonetheless, the bankruptcy judge decided that the net proceeds from a personal injury claim should be included in the calculation of disposable income. So in other words, for that court at least, even though the personal injury recovery would be an exempt asset, that debtor could end up paying most or part of it, at least, to creditors. Again, this is an issue on which the courts are split. Here is my suggestion for how to resolve these difficult Chapter 13 issues. We begin with the proposition that in the United States, an honest debtor is entitled to a discharge. And in these cases I'm talking about, there's no issue of dishonesty. It's merely a question of interpretation of the statute. Over the years, Congress has adopted what really amount to several hundred different exceptions. In other words, there are situations in which, according to Congress, a person is not going to get a discharge of debt, at least to some greater or more limited extent. Chapter 13 is a great example of that. But I believe that if we begin from the proposition that people get discharges, if you're going to, in effect, deny a discharge, the reason for that has got to be clearly set forth in one of those several hundred exceptions that Congress has created over the years. In other words, I don't think it's right to say that, well, this situation before the court is similar to another statute where there is, shall we say, an exception to discharge. And because it's similar, that's enough reason not to allow the debtor freely to obtain a discharge. When we have a statute with so many exceptions, I think if you're going to limit the right of a debtor to discharge its debt, the situation has to fall clearly within one of those several hundred exceptions all throughout the Bankruptcy Code. And by the way, I think that my method for approaching these difficult questions is very much in accord with our Supreme Court today. The High Court is not much in favor, if at all, of deciding cases based upon policy. It's the statute and nothing but the statute. You interpret the statute to figure out what the result ought to be in a particular case, and don't merely let the result stem from a court's interpretation of policy. And that, I think, is the underlying issue for these Chapter 13 cases. Is a circumstance clearly within one of the exceptions in the Bankruptcy Code? And if it's not, that's the end of the story. You can't deny the debtor's ability to get a discharge based upon the court's own notion of policy. As I said, the case that I spoke about today, as well as the others that I've referred to, are mentioned and linked in my column on May 22nd on the ABI website. So give it a read and tell me what you think. As I said, I'm Bill Rochelle, Editor-at-Large for ABI. I will be back same time next week with what I hope is another interesting issue unresolved in the area of bankruptcy law. Till then, be well, stay safe, stay at home, and let's hope that in the next few months we're able again freely to socialize. Good day.